Dear students, am I audible to you?
Yes, ma'am.
Yeah, we'll be starting the session within 1 minute. Okay. So today it's the second day of our online certificate course on intellectual property rights. So we're starting the program here. Distinguished speaker, Dr. Ananya Bibave ma'am, Vice Principal of Modern Law College. Dr. Rohini Jagtap, Principal, SNPP Law College. Colleagues and my dear students, I humbly welcome all of you to the second day of our online certificate course on intellectual property rights organized by SNPP Law College. It gives me immense pleasure in welcoming the guest speaker for the day, Dr. Ananya Bibave Madam. Madam is a performance-driven professional with 15 years of teaching experience. Presently, Madam is working as the Vice Principal of Modern Law College. Madam, I express my hearty welcome to this program. I also take this opportunity to welcome our Principal Madam, Dr. Rohini Jagtap, to this second day of our online certificate course. It is an honor for me to welcome all faculties to this session who sincerely committed to this event to make it a success. I also welcome all the students to this wonderful session. I once again welcome all of you to this program. Experience the fabulous session. Now I request Rachna Oname, the first year LLB student of SNPP Law College, to introduce the speaker of this day.
Hello everyone, welcome to today's lecture of this certificate course on intellectual property right. Firstly, I would like to thank our SNPP Law College Principal Dr. Rohini Jagtap ma'am and Assistant Professor Tintu Matthew ma'am for framing this certificate course for the benefit of the students. This task of introducing our guest of honor and speaker is a great privilege. It's difficult to limit her in few words, but I can say this with surety that she is an inspiration to thousands. It is my great pleasure to introduce Dr. Ananya Bibave, our speaker for today's topic on international and legal framework for property IPR. Protection of IPR. Dr. Ananya Bibave is highly qualified and has completed her education in Bachelor of Science in Law, LLB, LLM, PhD in Law, Postgraduate Diploma in Law, Certificate in Forensic and Medical Jurisprudence, Net Law, Set Law. She currently holds the position of Vice Principal at Modern Law College. Her research interests are environmental law, family law, IPR, and constitution. Ma'am has been part of several seminars as a resource person and has conducted 6 seminars herself. I genuinely feel we cannot have anyone better to introduce us with today's topic on intellectual property. Welcome, Dr. Ananya. Over to you.
Thank you very much. Let me just
Welcome.
share my screen.
Yeah, sure.
Is it visible?
Yeah, it is.
There are a few people waiting in the waiting room. You can just add them.
Yeah, we'll definitely let them in, ma'am.
All right. So should I keep my video on or can I switch it off? How would you prefer it?
I think like keep it on, ma'am.
It's
That would
for
be good.
your convenience, ma'am.
All right. Okay. So what I'll do is just minimize this. Okay. So today we are going to see the second session with reference to this course. I'm really very sorry. I'm having a little sore throat, so I might cough in between, but I will ensure that I will not disturb your link of information. All right. So today we are going to talk about the international and the national legal framework of IPR. Okay. This in itself is a very big topic. So what I'm going to do is I'm going to give you an overview of the evolution of the IPR law. What can be understood is what is written in the text. Okay. So I'm not going to tell you what is written in the books or what is written in any enactment. What I'm going to instead tell you or do is take you through a journey of the evolution of IPR. Okay, I will do that at 2 levels. I will do that at the international level as well as at the national level. All right. So what basically we are going to discuss in this today's discussion is what is IPR very briefly, because I think yesterday you might have got an idea about what IPR is. Then we are going to see the evolution of IPR right from the ancient times, wherever we can find traces of intellectual property or protection of intellectual property rights. Okay. Then we will look at the international scenario, that is at the public international law level. Okay. And then we are going to see the Indian scenario with reference to, again, the evolution of these various IPR laws. Okay. So the first question comes first is, what is IPR? Okay. So IPR, meaning intellectual property rights, it is a right which is special in nature and it is created due to the use of intellect to differentiate any item from the other. Okay, this is not any definition. This is what my perception of IPR is. Okay, so what is it? It is any item. It can be anything. It can be a patented work. I mean, it can be an invention. It can be a mark. It can be a design. It can be a literary, artistic, or dramatic work. It can be a geographical indication. It can be basically anything. Okay, so it is an item which can be differentiated from any other item. Okay, so what is important is we use our brains to differentiate one item from the other. We use our brain to create one invention which is different from the other. We use our brain to create a special mark which is different from the other. We use our brain to create a dramatic work or literary work or an artistic work which is different than others, and we can do that only because we can use our brain in it. Okay, so it is because of that usage of brain, that usage of your intellect, that this right needs to be protected, or this becomes a kind of a property. Okay, something which was originally not in existence comes into existence because of your effort, because of your intellect, and that is why you are responsible for that property, and therefore you should get a right over that property. That is basically what intellectual property right means. This intellectual property can be very broadly classified into two parts. It can be industrial property and there can be copyright. Of course, there are other intellectual properties also, but let us just prima facie broadly distribute it. Industrial property, what is industrial property? Any intellectual property that can be recreated into an industrial process which can be created in mass, okay, which can be therefore sold in mass, and therefore more and more money can be generated from it. So anything which is going to enhance your ability to earn money through some industrial process becomes an intellectual property which is industrial in nature. On the other hand, if there is any literary or artistic or dramatic work or a cinematograph film or any other thing like a performance, that will come into the arena of copyright. Okay, so these are the two broad classifications of it. Now we come to a little bit of a evolution from the ancient times. Okay, so let us see what was the concept of IPR in the ancient times. Where all can we find the traces of intellectual property rights in the ancient times? So the earliest records can be found from the 6th century BC from Sybaris in ancient Greece. Okay, a year-long exclusivity was given to bakers who made some culinary invention. बेकरी प्रोडक्ट कुछ नया किसी ने अगर बनाया तो उसको वो प्रोडक्ट बनाने के लिए 1 साल का एक्सक्लूसिविटी मिल जाता था. सो मोर और लेस वी कैन से दैट दिस वाज मतलब खाने से रिलेटेड इन्वेंशन को प्रोटेक्ट किया जाता था. However, it was not only that. There have been situations where remains of animals bearing early forms of branding were shown, which that the early humans attributed produce quality with the method of growing. Okay, so if X animal is branded with some particular mark, then that means that is the status of that. That is the quality of that brand, okay, of that animal or whatever it is. Okay, then this idea of adding a separate value on the maker and in extension on how they care for their animals, it shows the connection can be directly applied to the existing trademark and patent virtues. Okay, so ये जो है ना, मेरा अच्छा है, मेरा वाला better है, मेरा ज्यादा क्वालिटी वाला काम है, मेरा ज्यादा क्वालिटी वाली चीज है. Okay, so that has always been prevalent. Okay, whether it is protected or not is a different issue, but distinguishing one property from the other because of some additional intellectual effort has always been there. Okay, however, there were dark ages also where the impact of church became so high that everything under the sun which was created was deemed to be church property. Okay, that means God's property. Okay, so Emperor Zeno in 480 CE he overthrew the concept of sole proprietorship on artistic as well as agricultural produce. So the church gained absolute control over the entire empire. However, this could not remain for a very long time for very specific reasons, that if there is no incentivization, there is no growth, there is no development. And if there is no development, then the emperor or the government is not going to क्या कहते हैं उसे, the government will not develop, the government will not get any income, and therefore will perish. Okay, so this movement in which which in many ways is traceable in Aristotle and Plato's worldviews paved the way for enlightenment, and the first genuinely recognizable iteration of intellectual property appeared subsequently. Okay. Then we come 1,000 years later, 1421 AD May, for the first time, what we can call as the modern patent was granted in Italy. Okay, and even the licensing process, it was quite similar to what the modern licensing process is. However, this was with reference to industrial products. For the copyright, there was still a little more time to happen. Okay, but this was not, up till now, there were no legislations as such. Letters patent were granted. So what is a letters patent? A letters patent is a special document, a declaration by the seal of the king, stating that this particular company or this particular person or this particular group of people are entitled to something special which others are not. So it is a special privilege which is given on the document with the seal of the king. That is called as a letters patent. Okay. So there was no legislation which said that आपके पास ये attributes होंगे और आपके पास उसका एक outcome, एक product होगा, तो उसको हम इस तरीके से intellectual property को protect करेंगे. There was no such legislation. Everything was arbitrary. It depended upon the applications which were made, and it also depended upon the mood of the king. However, subsequently, for the first time in 1623, the Statute of Monopolies was created. Okay. So what was this statute for monopolies? It was an act of Parliament of England as the first statutory expression of English patent law. Okay.
स्क्रीनशॉट घेऊ द्या, पुढे चालले पुढे केलं पेड केलं स्क्रीनशॉट घेतला मला फॉरवर्ड करा व्हॉट्सअपला.
Yeah, so the patents, like I said, they evolved from the letters patent, which were issued by the monarch, okay, which used to grant monopolies to particular industries or to particular skilled individuals, or I can give you an example. In 1600, the East India Company also had got a letters patent with reference to exclusive marketing and sale of spices from India and Indian subcontinent back in the UK. That was a letters patent. Okay. So it was a special monopoly which was granted. But then subsequently, the Statute of Monopolies Act came, which confirmed that the monopolies were contrary to common law, but made exceptions for patentable inventions. Okay. So whatever patentable inventions were there, they could be excluded. In short, the Statute of Monopoly created the exclusion or the special status of patents for the first time. Then comes the Statute of Anne. Okay. Now this Statute of Anne, which came in 1710, it was with reference to publication. It was with reference to literary work. It was not with reference to industrial property. Okay. It granted a legal protection of 14 years on the book, which was such as such registered under the Anne Act, the Statute of Anne, from the commencement of the statute. Okay. It also granted 21 years of protection of any book which is already in print. Okay. So this was the old scenario. Now, subsequently, what happened? That industry started growing, travel started happening, and international interactions beyond war, beyond fighting, beyond, accessing someone's territory and having a war and claiming their country. Beyond that, trade and commerce started growing. Because trade and commerce started growing, people realized that different countries have got different legislations, different laws to safeguard different things. Okay, so if one country, let us say if we are talking about the UK, they had the statute of monopolies, but let us say some other country like China did not have it. So whatever products were created which were sold in this other country, they were completely without any protection. People could use it, people could see them, people could open them out and see what were the parts in it. People could replicate them and they could misuse basically the products. However, because of these problems, a need was felt at the international level that something has to be done. Okay, now we are not talking about a strong, let us say the United Nations organization or something. ये तो बाद में हुआ. You know, even before that, countries came together for the first time for trade. Okay, so for the first time in 1883, the Paris Convention was signed. What was this Paris Convention all about? It was about industrial property. Okay, so it was about patents, trademarks, designs, utility models, service marks, trade names, geographical indication, and unfair competition. So there were 8 different things that were restricted, controlled, prevented through the Paris Convention. Now, needless to say that because it is a convention, unless and until a country, a member country, a country signs to the convention, the rules are not applicable to that particular country. Okay, so whoever are the signatory parties, the people who are living in those countries have a protection for patents, trademarks, industrial designs, utility models, service marks, trade names, geographical indications, and so on. Okay, so what was the requirement? That the country should sign the convention. Sorry. So if we look at the substantive provisions of this convention, we can find that it can be categorized into 3 main parts. First is called as the national treatment. Second one is called as the right of priority. And third one are certain common rules. Okay. So what do you mean by national treatment? Okay. Whenever a country makes any law, it is generally applicable to all people within that country, or it is made applicable to a class of people to whom or for whom the law is actually made. Okay, so everyone gets a treatment of equality with reference to that particular law. Okay, so the concept, what is there of equality at the domestic level, at the national level, the same concept of equality, if we want to make it broader and if we want to make it internationally applicable, it is called as national treatment. Okay, why national treatment? Let us take India's example only. We have part 3 of our constitution, which speaks about fundamental rights. Okay, these fundamental rights, the state cannot take them away. If any state tries to take it away, we can directly go to the High Court or the Supreme Court and they will grant us those rights, no matter whatever justification the state gives, isn't it? So what is national treatment? National treatment as if it is for their own citizen that they are protecting those rights. Okay, so even if, let us say, I'm not a citizen of a particular country, let us say I'm not a citizen of the UK, यूनाइटेड किंगडम की मैं सिटीजन नहीं हूं, तो यूनाइटेड किंगडम में मुझे स्पेशल ट्रीटमेंट देने की एक्सपेक्टेशन नहीं हो सकती है. However, because I have signed the Paris Convention, or let us say India has signed the Paris Convention. Tomorrow, if I want to make an application for, let us say, a patent in the UK, I can do it and I can have the equal status, just like another person, Mr. X, who is a citizen of UK and is making a patent application. And maybe, if at all, my patent and his patent is on the same or a similar topic or a similar product, and I have made an application prior to him, I will have a priority date, and therefore my patent, my product will be safeguarded. That is what is called as national treatment. So treating every person who is a member of the member countries, who is the citizen of the member countries, treating every person with equal status. Okay, not bifurcating between your own citizens and outsiders, जिसको हम alien कहते हैं, alien कहते हैं, ठीक है? So national treatment, that is the first thing. Second thing is the right of priority. Okay, so what do you mean by right of priority? Okay, so right of priority means, so first of all, let me just tell you one more important thing with reference to intellectual property rights. They are time bound. Okay, most of the intellectual properties are for a specified period of time, except for, let us say, trademark or geographical indication. There is a time period specified. So time is of a very important factor over there. The lapse of time is going to lose you out on the possible money that you could have made. Okay, so the earlier you apply, the earlier you get a grant of patent, the earlier you can use that patent and make money. At the same time, because it is directly connected with your intellect, okay, अब किसी के दिमाग में घुस के तो कोई ये नहीं देख सकता कि मेरे दिमाग में वो आइडिया आया था या नहीं आया था, isn't it? So it inevitably, if you want to check who has made the invention, it will always be with reference to किसने application सबसे पहले किया, isn't it? So priority date means a date which gives you a right of priority. Okay, now especially in patents, what is required is that the patent or the invention should not be published prior. Now, it is not physically humanly possible to make the application for patent in, let us say, I want to sell my product in 5 countries. So what I do today, at the same time, I make an application in 5 different countries, where I only have to make an application, like me physically has to go there and make an application. It's not possible. So does that mean that once I make an application in country A, I lose the opportunity of getting benefit in country B, C, D, E? The answer to that, because of the Paris Convention, was no. So 12 months for utility patents and utility models and 6 months for industrial designs and marks was given as a additional time period within which a person could make an application to many other countries or to any other country, if at all he wishes to, after making an application in the first country. Okay, so the date on which he had made the first application in the first country will be treated as the date, as the priority date of that application in all the other countries, so that there would not be a let us say misuse of the procedure. Okay, then Third is that there are certain common rules which need to be followed. Now, why this needs to be created, or why these rules were created, was because, like I said, every country had one way or the other to protect their rights. Okay, some countries did not have the protection, patent protection regime or anything, or IPR protection regime was not there. But there were some countries in which it was there. But even if when it was there, the rules were not same. So some place you had to just make an application, a written application was sufficient. Some place you had to show your product. Some places you have to, let us say, some places the time period was 2 years, some places it was 10 years. So there was no consistency in the process. Therefore, the Paris Convention brought in the consistency, uniformity, so that one person, if at all he's making an application to 4 or 5 different countries, the procedure should be a little bit similar, and the rules also should be a little bit similar, because it was impossible otherwise for one person to follow one set of rules in one country sorry, and another set of rules in another country. Okay, so sorry, the patents granted in different contracting states for the same inventions were treated as independent of each other. Okay, and the granting of patent in one contracting state sorry, does not oblige the other contracting states to grant a patent. ठीक है, एक स्टेट में एप्लीकेशन कर दिया, उस स्टेट ने अप्लाई आपका एप्लीकेशन एक्सेप्ट भी कर दिया. That does not, however, mean that every state will make, will accept your application. Some states might be having some stringent rules. Some states might not be having those stringent rules. So, because one patent is granted in one country does not make it applicable to every country. Okay, every country's rules have to be followed. Okay, then the inventor has a right to be named as such in the patent. जो ट्रू एंड फर्स्ट इन्वेंटर है उसको उसका नाम होना चाहिए, उसका नाम एक्नॉलेज किया जाना चाहिए. ओके, the grant of patent may not be refused, and a patent may not be invalidated on the ground that the sale of the patented product was done in some domestic law. Okay, is subject to the restrictions or limitations resulting from some domestic law. Okay, then each contracting state that takes legislative measures providing for the grant of compulsory licenses to prevent the abuse which might result from exclusive rights which are conferred by the patent may do so under certain conditions. See, if you look at these provisions, you will understand that yes, a certain amount of control was created. However, it was a very vague kind of a control. Okay. Say for example, for marks, it did not regulate the conditions for filling the registration of marks which are determined in each contracting state by the domestic law. So, एक country में कुछ और rules होंगे, दूसरे country में कुछ और rules होंगे. This was the process. Okay. Consequently, no application for the registration of mark filled by a national of a contracting state may be refused, nor may a registration be invalidated on the ground that filling, registration or renewal has been effected in the country of origin. तो मैंने दूसरे country में apply किया, तो दूसरे country का अपने rules होना चाहिए, अपना जैसा procedure है वो होना चाहिए. ठीक है? Then we come to collective marks. Okay, so Paris Convention for the first time allowed collective marks also. Okay, so what are collective marks? Marks which are, let us say, a common mark which is applicable to a group of items along with some other specified marks which are there along with them. So collective marks also distinguish, let us say, like the company name and the product name. So a company might be selling 10 different products. the company mark will be the same, but every product might also have a mark on it. So the product mark will be the trademark of that product, as well as the company mark will be the collective mark which will be there for all of the products. Okay, so they were introduced. Then for industrial designs, the protection should not be forfeited on the grounds that the article incorporating the design are not manufactured in that state. Okay, so you can import also, but still if it is your design that is being made in some other country, you can import it and you can sell it in some other country also. Okay, then trade names, the protection must be granted to the names in each contracting state without there being an obligation to file or register the names. So if your trade name is there in one country, it will be there for all countries. Okay. Then indications of source. So this is like the geographical indication. Okay. So measures must be taken by each contracting state against the direct or indirect use of a false indication of the source of goods or the identity of their producer, manufacturer, or trader. This is again very important. It falls a little bit within the trademark or regime also, and a little bit into the geographical indication also. Lastly, the Paris Convention also talked about the unfair competition. Okay, now technically, this is not a part of intellectual property anymore. It is a part of the competition law. Okay, however, at that time, it was even this was thought about, and therefore it was held that each contracting state must provide for an effective protection against unfair competition. Okay, so this was about Paris Convention. इसमें इतने लोगों ने, इतने countries ने ये किया, इतना उसमें amendments हुए. I'm not going to go into those details. Then comes the second convention, and that is the Bern Convention. Bern Convention, Germany. So this convention deals with the protection of works and the rights of the author. So this is with reference to the copyright law. Excuse me. So it is based on three basic principles again. Determining minimum protection to be guaranteed, as well as the special provisions available for developing countries who want to make use of them. Okay. So works originating from one contracting state must be given the same protection in each of the other contracting states, as the latter grants the works to its own national. Okay, if you have studied international law, you will understand the concept of reciprocity. Okay, reciprocity means whatever rights and privileges I have in, let us say, country X, the citizen of country X will also have the same rights and privileges in my country. Okay, this is called as reciprocal behavior, that is reciprocity. In the similar way, what we saw in the Paris Convention, the same thing we are seeing over here in Bern Convention, national treatment, the treatment of equality, which is expected. So, जो भी इंसान किसी मेंबर कंट्री से बिलोंग करता है, उसे अपने कंट्री में जो ट्रीटमेंट मिलना चाहिए, वही ट्रीटमेंट, ऑफ कोर्स विद रेफरेंस ओनली टू द कॉपीराइट, वही ट्रीटमेंट उसे दूसरे कंट्री में भी मिलेगा. ओके, सो then secondly, the protection must not be conditional upon the compliance of any formality. Okay, this second principle is special to Bern Convention. It is called as automatic protection. Okay, and third is protection is independent of the existence of protection in the country of origin of work. So in the country of origin, even if the protection may not be granted or has not been granted or has been let us say revoked, still if I make an application, or if I happen to be, my work happens to be in some other country which is a member country to the Bern Convention, then in that other country my work will be protected. Okay, so this is the independence of protection, principle of independence of protection. Okay, now there are certain minimum standards of protection under the Bern Convention also. Firstly, every production of a literary, scientific, and artistic domain, whatever is the mode or form of expression, it is called as a work. Okay, subject to certain allowed reservations, limitations, or exceptions. Sorry, there are certain rights as exclusive for authorization. What are these rights? Right to translate, right to make adaptations and arrangements in the work, right to perform in public dramatico-musical or musical works, then right to recite literary works in public, right to broadcast in public, right to make reproductions in any form, and right to use the work as a basis of for an audiovisual work, the right to reproduce, distribute, or perform in public or communicate to the public that audiovisual work. Okay, so आपका work जो है वो ना ही सिर्फ
Hello, ma'am. Is the session stopped?
sorry, there was some problem with my internet and the electricity. I hope I'm audible.
Yes, ma'am. Now we are audible, ma'am.
Okay, now because I have less bandwidth, I'm going to only show my screen. So please excuse me for that.
Yes, ma'am. Sure, ma'am. Please continue, ma'am.
Okay, all right. Is it visible? Is my screen visible?
Now it's not visible.
Okay, just a minute. Yes, now it might be visible. Is it?
Second, ma'am. 1 second. Let me check. Now it is visible, ma'am.
So let me just continue. So
Yes.
this was what the Paris Convention and the Berne Convention had impact on the international, at the international level with reference to the protection of intellectual property within one country and within many countries at the same time. Okay, so yesterday you might have understood that intellectual property laws are domestic in nature. They are always connected with one single country. Therefore, there needs to be a special protection for every country in which you want to use the law, use the right, isn't it? So that is why the Paris Convention and the Berne Convention were useful at that time. Okay, let me just quickly, I'm not going to go into the details of this because there is a lot of it. Okay, however, I will share with you the PPT.
Dear students, please wait. There is some internet issues from ma'am's side. Please wait. Yes, ma'am. Now the image is visible. Screen is visible.
Okay, thank you. I'm really sorry for this connectivity issue. It just came up just now. I don't know, something. It is always said that Murphy's law applies over here. Okay, so let us quickly go ahead to the Madrid Protocol. Now, this Madrid Protocol, specifically with reference to the procedure for application of registration for trademark. Okay, it is not a substantive law as such. It is just a protocol which tells us what to do, what right do you have, where to apply, and how to get the trademark registered. Okay, so it is a cost-effective way and an efficient way for trademark holders to ensure protection of their marks in multiple countries through filling of one application with a single office in one language. I guess I'm having a connectivity issue. I will just change my place. I will go somewhere else so that there will be internet.
Yes, ma'am.
Okay. Am I audible here?
Now you're audible, ma'am.
Okay, I'm having a little better connection over here. Just let me share my screen.
Yes,
All right.
ma'am, screen is visible now.
All right. So this Madrid Protocol, there is a step-by-step process which is given. First is you have to make a basic application. Once you make the application, either the World Intellectual Property Organization, the WIPO, will examine the application. It conducts a formal examination, and if at all there are any irregularities or anything, then you need publication as trademark should not I mean multiple people should not get the trademark of the same kind of a thing. So there will be a publication, then there will be subsequent examination by the trademark office of the designated country. Okay, once that is done, there will be advertisement of the trademark and then registration. This is a simple 6-step procedure which is given under the Madrid Protocol. Now, because trademark can be renewed, because it is a continuous process to create a product and to sell it under the same trade name. So the process of renewal is also given under the Madrid Protocol. With this, we come to the next area, that is the WIPO, the World Intellectual Property Organization. Now, initially, this Paris Convention and the Bern Convention, there was a group of members which were created, and there were meetings which were supposed to be held, and there was a secretariat which was supposed to be made. What happened is subsequently, instead of making separate organizations for industrial property, for industrial intellectual property, for copyright and for trademark, what they did was they created a common organization which was supposed to take care of the whole of the intellectual property. So it is called as the World Intellectual Property Organization. Okay, they governed the central governing bodies, and the United International Bureau for Protection of Intellectual Property, it was now subsequently called as the World Intellectual Property Organization, or the WIPO. Okay. All right. So then subsequently in 1974, the World Intellectual Property Organization, which was technically a separate body. It was merged into the United Nations organization as its branch, one of its branch. Okay, so it was a separate convention with which it was created, but in 1974 it was merged with the this thing. So it is it administers 26 international treaties that concern to a wide variety of intellectual property issues, ranging from the protection of audiovisual works to establishing an international patent classification. Okay, so all of that is done in through the WIPO. Currently, there are 193 member states of the WIPO. Okay, I think we can go ahead. Okay, so that was World Intellectual Property Organization. Now we come to the next level, and that is the GATT and the World Trade Organization. Okay, GATT is the General Agreement on Tariffs and Trade. Okay, so you might have heard about the evolution of international, when if you might have heard about the evolution of international law, that after the two world wars, it was suddenly felt by the countries that it was necessary to reduce the possibility of friction within countries, and also to have a separate regime for having good economic connections and interactions with other different countries. Okay, so with that intention, a general agreement on tariffs and trade was created in 1945. Parallelly, the United Nations organization was also created in 1945, but that the purpose of United Nations organization was public international law. GATT, on the other hand, the General Agreement on Tariffs and Trade, was going into the domain of international economic law, or let us say private international law to a certain extent. Okay. Now, this 1945 GATT was subsequently amended, and a new General Agreement on Tariffs and Trade came in 1991. Remember, globalization, liberalization, privatization happened during this time. And the outcome of this 1991 GATT was the creation of a World Trade Organization in 1995. This World Trade Organization created a number of multilateral and bilateral agreements with any countries which were a member to these this World Trade Organization. Okay, so there was a common set of multilateral agreements. Multilateral agreements are agreements which are signed by many countries together, and bilateral agreements are agreements which are signed by two countries. Okay, there can also be a third type of agreements, plurilateral agreements, where many countries on one side signs a treaty with one single country on the other side. Okay, so a various set of agreements were created, and the countries who have signed the WTO were bound by all the agreements which were being signed by them under the WTO itself. Okay, one of those agreements is called as the trade related aspects of intellectual property rights, or the TRIPS agreement. Okay, so what is there in this TRIPS agreement? Now, if we look at the tariff and trade, or let us say the international trade altogether, what is it that hampers the trade the most? If we ask this question, the answer would be uncertainty. Okay, what do you mean by uncertainty? I don't know how much money I will get for my product. I don't know the currency rate. I don't know what taxes will be imposed upon me if I sell my product in another country. I don't know what will be the procedure for import and export. I don't know what will be the customs duty. What is this? This is insecure, unsurety. Sure nahi hai na hum. Mujhe, let us say, for example, if I'm a seller in India and I'm selling in India itself, I know all the laws, I know all the rules. But if I am selling, let us say, in the current scenario of Sri Lanka, or if I'm selling in, let us say, Latin American country which is way far away from me, for me to go behind and ask for money 10 times, I am going to be uncertain. And if I'm uncertain, I'd rather not take the chance and I will leave the chance. I will say I will not go and trade only, isn't it? So if at all there are ways in which we can enhance this trade, if at all there are ways in which we can reduce the uncertainty and bring equality and parity, it will be easier for people to do international trade. Okay. One of the factors of uncertainty is what will be the fate of my patented product in some other country in which I have no access. Okay, so if I go and sell that product in my country, I am having my patent protection, but that is only in my country. If any other member of another country tries to sell that product, recreate it and sell it, I don't have any other rights against that person in that country. If that is the situation, I would rather not sell anything in the other country. And we should always remember that whenever there are inventions and whenever the inventions are sold, growth and development happens, isn't it? So that is why the trade related aspects of intellectual property has to be taken into consideration. Okay, so what are these aspects of intellectual property? Okay, so there are three main issues which are governed by the agreement. Okay, what is the standard? What are the standards of intellectual property? What is the process of enforcement of this intellectual property? And if at all there is a dispute, what is the process for settlement of the dispute? Okay, standard क्या होना चाहिए? मतलब क्या है कि एक कंट्री में जो भी बेसिस होगा उससे बहुत ही ज्यादा डिफरेंट दूसरे कंट्री में नहीं होना चाहिए. Somewhat similar at least a certain level, all the intellectual property protection should be able to be done in all countries. मतलब मान लो कि इंडिया में इन्वेंशन जो है वो न्यू इन्वेंशन which has an inventive step, उसी को सिर्फ पेटेंट मिलता है. और लेट अस से यूक्रेन में डिस्कवरी को भी पेटेंट मिल जाता है. तो फिर अगर इतना ग्लेरिंग डिफरेंस है तो फिर वो स्टैंडर्ड मेंटेन कैसे होगा? That is why certain basic parameters were created under the TRIPS agreement as a standard so that all the member countries will have to comply. Now please remember this part, because of this TRIPS agreement, Indian intellectual property laws, all of them literally, have been amended. Okay, we did not have certain provisions prior. Now we have those provisions because we are a member to the TRIPS agreement, we are a member to the World Trade Organization. Okay, so all member states are required to provide a minimum set of criteria for the protection of IPRs in each of the IP category covered by the agreement. Each area is addressed in such a way that the major aspects of protection, such as subject matter, sought to be protected and the rights to be granted and the possible exceptions to such rights, as well as the minimum period of protection, are all explicitly stated. ये चार चीजें सबसे ज्यादा मैटर करती है. कौन सी राइट को प्रोटेक्शन मिलेगा, एक्सेप्शन क्या होगा, क्या राइट्स होंगे और मिनिमम पीरियड कितना होगा. ये चार चीजों के बारे में if we have a knowledge, then we can have a basic understanding about how my right will be safeguarded. Okay, then the second aspect is the enforcement. Okay, so who will enforce? So IPR जो enforce करेंगे, it includes the rules in civil and administrative processes and remedies and provisional measures, particular border requirement, as well as criminal proceedings. Everything has to be earmarked. Okay, and if at all there is a dispute, then the settlement of the dispute under the TRIPS agreement will be under the World Trade Organization dispute resolution process. Okay, This TRIPS agreement is divided into 7 parts. First is about the general principles. Then second part tells us about the requirements of availability, scope and application of IPR. Third part speaks about the enforcement of IPR. Fourth speaks about the procedure for obtaining and maintaining IPR. Fifth one is the prevention and resolution of conflicts resulting from the provisions of the agreement. Sixth one is about the transitional agreement, and seventh one is about the variety of institutional arrangements. Okay, so these are the 7 parts in the TRIPS agreement. I am going to go into the details of each of the parts. Okay, I have made a gist of all of the parts, of all of the rights which are covered. Okay, now we come to the Indian part. Okay, now India has got a very different perspective of looking at intellectual property. Okay, we follow under the ancient traditions the concept of dharma. Okay, and this concept of dharma tells us that whatever we do, we should not keep it to ourselves. We should give it away to people so that they could be benefited. In turn, they would give us some positive क्या कहते हैं, कुछ पुण्य मिलेगा जिसके वजह से अब हमारा लाइफ भी अच्छा हो जाएगा. Okay, so our philosophy, old ancient Indian philosophy, is about giving. It is not about protection. It is about giving the benefit, maximum benefits to whoever comes your way. Okay, even if sometimes you may be at loss, the larger goal is to be a giving person, so that at the end of the day, at the end of your life, you don't have any regrets. Okay, that is old Indian philosophy. Now this philosophy is completely against the concept of protection of intellectual property. However, this philosophy cannot justify industrialization and growth and development, because incentive is a very, very important part which plays in the thought process of any person. Okay, what do you mean by incentive? So if at all I want a small child to do some work, I will say that if you do this work, you are going to get a chocolate. That chocolate is an incentive. In the same way, when we start studying, when we are in schools, our parents generally tell us that if you do well in your examinations, you are going to get this in your vacation, or you will get this as your gift. Cycle milega, nayi ghadi milegi, jo bhi hai. ठीक है? So what is this? This is incentive. So if at all I am taking additional efforts and creating something out of my own intellect, the incentive for me to create more such stuff is what? Is that this product, this thing which I have created, will be protected properly. So if it is, let us say, a patent, then if I sell the product, I will get money. If it is a copyright, for example, then if I sorry, if I sell the book, I will get money for it. If I sell the picture, I will get money for it. Or at least people will know, people will acknowledge that this is my work. Okay, this is my work. मतलब जैसे हम कहते हैं ना, लियोनार्डो दा विंसी का work है Mona Lisa. Okay, so this is attribution, and this attribution is also very important. Okay, so that is why let us now see the evolution of intellectual property rights in India. Okay, although we don't have that thought process, because of the government incentivization for growth and development in industry, it was taken in the Indian this thing. Now, again, let me also tell you that the Indian intellectual property regime did not start or did not happen by its own. Because India was a colony of the British, the intellectual property laws which were there in Britain were subsequently applied or enacted for the purposes of India also. And why was this done? This was again done so that the Britishers could do trade and commerce better, easier. Okay, so that their rights are not, won't get hampered. Okay, so the first legislation with reference to patent, it came in the Act number 6 of 1856. Okay, this was subsequently repealed in 1857. Then again, a fresh legislation for granting exclusive privileges was introduced in 1859. Okay. Then the act excluded the importers from the definition of inventor. It was based basically on the 1852 Act of the UK. Okay. Then in 1872, this 1815 Act was then consolidated, and the Patents and Designs Protection Act, or patents, Designs Protection Act was created in 1872. This Act of 1872 was then was there for around 30 years. Okay. Then in 1883, certain modifications were made in the UK, and therefore in 1888, an act was introduced to consolidate and amend the law relating to the designs, inventions and designs in conformity with the UK law. Okay, ये हुआ 1888 में. Based upon that, in 1911, the Patent and Designs Act of 1911 came into existence. This is so far the longest act that was prevalent in with reference to patents in India. Okay, इसमें amendments हुए 1920, 1930, 1945. Okay, but more or less it was there for a very long time. After independence, it was then thought that the patent law should be amended. So 1949, a committee was established, and on the basis of these parameters, these 7-8 parameters, the committee was supposed to give its report. The committee gave its report in 1949 itself, and there was certain amendments which were suggested in the act. However, 1911 wala ye jo act hai, it was amended in 1950, later again in 1952, then in 53, but as such, till 1970, the 1911 Act was only applicable. Okay. What all happened in 1957? Again, another committee, Rajgopal Iyengar committee, this committee made a lot of recommendations. 4 बार उसके बाद में the law was tabled in the parliament, but it was lapsed. Okay, for one reason or the other, the law was never passed. Finally, in 1970, the act was passed, which made the Patents Act of 1970, and the Patents and Designs Act of 1911 now remained only to the extent of Designs Act 1911. Okay. This act was amended in 1994-99, and then subsequently they thought that this law would be sufficient, even if it was just a few amendments which were to be made. But they realized that the TRIPS agreement had got a major difference in the approach with reference especially to the medical patents, to the pharmaceutical patents. Okay, patent and process patent both were could be patented. Okay, so finally on because the last date was given as 31st of December 2004 for making any subsequent changes according to the TRIPS agreement in all the laws. So the Patent Act was amended, and finally the Patent Act of 2005 into existence, and it was applicable from the 1st of January 2005. Okay, now जितना प्रोसीजर ये पेटेंट एक्ट में हुआ है उतना अमेंडमेंट्स, उतना नया प्रोसीजर किसी और लॉ में नहीं हुआ है, फॉर द सिंपल रीजन दैट द पेटेंट लॉ इज द मोस्ट ल्यूक्रेटिव लॉ. Okay, it gives you an exclusive production and marketing right, and you can exploit the product, you can exploit your patent to whatever level possible. Okay, so if your product is good and if you have a good production line, you can reach the sky. In fact, sky is the limit. Okay, so that is why the patent law was always looked up and amended accordingly, as per the requirements of the time. Then let us see the copyright law. Okay, so it was enacted by the British colony, like most of the other acts, in 1914. Okay, it was actually a replica of the British Copyright Act of 1911. There were amendments which were made in this act in 1957, 1983, 84, 92, 94, 99, and 99 act made it in consonance with the TRIPS agreement. Okay, in May 2012, again an amendment was brought in the Copyright Act. Okay, so yeah, this is again what it is. Post independence, 1957 came the new Copyright Act, which amended the 1911 Act. We've already seen this, so let me not go into the details of this. Okay, then comes the trademark law. So proprietary protection of marks was there in India. However, what we can call as the trademark law, the modern trademark law, that started in 1860. Okay, so prior to 1940, there was no official trademark law, but the English trademark law was only being made applicable. Okay, but because of that, there were numerous problems which arose, and the law relating to passing off, which was a common law remedy, that was not, I mean, people started misusing it in a way, and therefore section 54 of the Specific Relief Act was supposed to be, I mean, it needed to be made applicable time and again. And because of this problem, finally the trademark law was created. Okay, the Trademark and Merchandise Act, it was repealed, and then subsequently in 1999, according to the TRIPS agreement, the Trademark Act came into existence. Okay, lastly, we will come to see, okay, there were amendments made subsequently in 2002. So we have seen industrial designs, we have seen patents, we have seen trademarks, we have seen copyrights. There are certain other intellectual property also which are protected in India. I have just named a few. There are many. So the first one which I would like to tell you about is geographical indications. So a geographical indication is a exclusive marketing right which is given to a place. Okay, it could be either an industry or it could be a product which is grown in that particular area. And whoever member of geographical indication only can apply the GI mark to the product. Okay, because of the GI mark, the origin of the product is safeguarded and people know exactly the origin of the product, because of which they can fetch greater money. Okay, then comes the layout designs of integrated circuit. Okay, so you might be knowing about the computers and the generations of computers. It was in the second generation of computers that the integrated circuits came into existence. Okay, ICs jinko kehte hain. Now the beauty of this integrated circuits is that if you replicate an integrated circuit without knowing what is the path or what is the process or how, whatever is the intention behind creating the first IC, the second integrated circuit, which is a replicated one, will have same power, perform the same functions like the first one. So you don't actually need to do any of the other stuff. All you need to do is replicate and you get the whole thing sorted out. Because of this, the layout designs of integrated circuits are a very important aspect of protection with reference to computers. Now, we also know that the development in computers have exponentially happened, and therefore this layout designs of integrated circuits need to be protected, and the greater protection given, the safer it is for new generations of computers to come. All right, then comes, and not just computers, I'm talking about all the electronic devices which has integrated circuits installed in it. Okay, then there is protection of plant varieties and farmers' rights, which speaks about protecting specific plant varieties. We have the Biodiversity Act. We have the we have a lot of laws which can directly or indirectly be connected with intellectual property rights. So this is about the various intellectual property laws which are available internationally, the evolution of these laws, as well as the different intellectual property rights which are there, which we need to know. Okay, every single intellectual property right has got a legislation of its own. Okay, so it is just not possible for me to cover everything in this one small lecture. But if you have any doubts, any difficulties, anything, any questions, please feel free to ask, and I will be more than happy to answer you. Thank you very much.
Thank you so much for sharing your knowledge with us, ma'am. Students, if you have any queries, if you have any questions, it's the right time to share. Please ask questions. Yeah, any doubts?
I will be sharing this PPT with you. So if you have any questions subsequently, you can post it to ma'am and I can get back to you.
Yes, ma'am. Okay, then, so it's a time, it's almost a time to end the session. So let me come to the vote of thanks. It seems to be a great honor to propose the vote of thanks to all who have helped us in making this webinar a very resounding success. First of all, I would like to give my hearty vote of thanks to our distinguished speaker, Dr. Ananya Bibave, ma'am. I thank you, madam, from the bottom of my heart for taking time from your busy schedule to be the guest speaker for this program. Your presence and wise words help magnify our cause in the best possible way. All thanks to your enlightening words that inspired our students. I would like to express a deep gratitude to our principal, madam, Dr. Rohini Jagtap, for her presence in this webinar. I also express vote of thanks to all faculties who has made this program a grand success through their motivation and dedication. Finally, I thank all our students for your cordial cooperation. Thank you once again. Thank you, ma'am.
Thank you, ma'am.
Thank you.